Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Hi, welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Real Estate Group, and today we're joined by our host Jim York and his guest Celia Deifik, attorney with the law group Lanier and Deifik.
Thank you, Morgan, for the introduction. Well, thanks for coming back on the show again. Let's tell our viewers a little bit about yourself, okay?
I'm with Lanier and Deifik downtown. I've been practicing for over 30 years in Florida. I'm board certified in real property law, and I've been continuously board certified since 1990, which involves getting recertified by the bar every 5 years. I use my real estate background. I used to do transactional work. I don't anymore. I use it to focus on real estate litigation. And I do business litigation. Also, often it's interrelated with the real estate issues.
Well, we're here today. You know, we just had a hurricane here, but you know, Florida, we have rainstorms, windstorms, we have all different kinds. I mean, in different parts of the country, they have earthquakes and they have snowstorms.
Fires, mudslides.
Right, so it's not unusual that certain areas have different kind of weather problems. So let's talk about associations today, because, you know, let's talk about, do they have adequate insurance to cover this? And if they don't, what happens to the people that are members of the association? What are the liabilities? Or can you just start to explain a little bit about that?
Sure. And I'd like to start off with an interesting trend that we've seen in Florida. I've been doing condominium law and homeowner association law for decades. When I first started practicing, the law was rather short. It's been expanded. But what I have seen through almost all of that time has been the deference of the legislature and the courts to the board of directors. The attitude of the courts has been, hey, we're trusting the directors as long as they behaved like prudent businessmen.
Right.
They were on the ground, they know what's happening, we're not going to interfere. Recently, the legislature has taken a very different approach. And I think, as we spoke on this show once before, this came out of a grand jury report out of Miami-Dade County, where a great deal of corruption was exposed, and there was a great deal of self-dealing amongst board members and management companies. Now, I don't think that every board of every community association is corrupt, but I will tell you that there is certainly a trend now to scrutinize everything board members, officers, and management companies do far more closely. So having said that, I think that after a hurricane such as this, insurance and reserves are the areas where the rubber meets the road. So the first thing that we think about is insurance. Does the association, whether it's a homeowners association or a condominium association, does it have adequate insurance? There is a difference often between what a declaration that was written 20 years ago defines as the insurance they should have and what the law says. And I will tell you that this is one of those instances where the law will prevail. And if the association, and by that I mean the boards of directors, have not adequately insured per the formulas in the statute and with the assistance of experts as the statute requires, they will be held to account for breach of their fiduciary duties.
So what you're saying is that if these things were put together 20 years ago and they haven't been updated, correct? That the board is liable for it.
Well, a
Is that what you're saying?
I'm saying that a competent board,
Right.
a responsible board, should be taking the classes that the division requires and provides, and should be keeping up with the law and consulting with their CAM, their community association manager, who's adequately licensed, and they should know where the law has trumped their documents. Another area that I think will be of concern is the deductibles. The statute, the condominium statute, does give discretion to directors as to setting the deductible that will be acceptable in their policy. But it's not unfettered discretion. There's a lot of things that must be considered. Now, where there's going to be a great deal of dispute and unhappiness is between unit owners and associations where the unit owner has not adequately insured their unit. Because what people do not realize, and again, sometimes you see declarations that were written 30 years ago. Frequently, we have people come in with a declaration that they got when they purchased 30 years ago. When we look online, we see it's been amended several times, but the unit owner doesn't have the amendments. The unit owner is sometimes relying on a very old and out-of-date version. The law requires absolutely now that every unit owner have their own insurance that complies with certain insurance laws, covers floor, wall, and ceiling coverings, appliances, fixtures, things within the unit. We have seen people who have, for instance, liability insurance, but not hazard insurance, and are presuming that the association will make them whole for their furniture and carpet and things.
Right.
Not only can the association not likely do that, the statute says the insurance that the association was supposed to buy is absolutely not allowed to include insurance for those things. And the legislature has a statement in the statute. This is the public policy of the state of Florida to lower premiums and ensure a smooth market. Now, the owner can recover from other unit owners or the association in some limited circumstances where they can show it was the negligence of the other party.
Right.
It's not always that easy to show.
Well, we're going to take a little short break here, and we're going to take a little commercial about the York real estate team, and then we'll be right back and finish this up about associations. Thank you.
Thinking of buying or selling a home in Naples, Bonita Springs, or Estero? Think of the most experienced realtors. The York Real Estate Group of Downing Fry Realty. Let's have a look at what the McLeans have to say about their experience working with the York Real Estate Group.
Jim York was our broker in acquiring our present home in Bonita Springs. His knowledge and integrity made the process go very smoothly.
It was a pleasure doing business with Jim York. Everything was done in a superbly professional manner.
Welcome back. How about the units that are for sale in a association or a condo association?
Well, we're seeing a lot of issues come up, and those are coming up whether the association or the unit owner didn't have adequate insurance, because they could assign those insurance proceeds under their contract, or because the association didn't have adequate reserves. And again, we get into the fiduciary duty of the board. Were reserves properly calculated? And if they were waived, were they waived properly? We're seeing litigation where people want to terminate their sales contract because there's been damage to the home or the condo, and the seller is arguing over what level of damage has to be shown. There's contradictions in some of the residential sale contracts that are commonly used. For instance, it may say the risk of loss is on the seller until closing. Another provision might say any special assessment arising after closing is the responsibility of the buyer. Well, they're going to be coming because of the hurricane.
Right.
So there's going to be a lot of disputes.
And how about casualty and the deduction is 100% now? You can write it
Yes,
off? Yes,
it's my understanding, I'm not a tax attorney, but it's
Right.
my understanding from talking to someone who is, that it used to be you could only deduct the amount of your casualty loss that was above a certain percentage, like 5% of your income.
Right.
So you might have spent a lot of money, but you could only deduct on your income tax a small part of it. As of 2017, it's my understanding, you can deduct all of it, and that's a major change.
Yeah, that's a major change. How about the termination of a condo?
Well, we are seeing some condominiums around the state that are so badly damaged, it's not worth rebuilding, and the owners may decide best thing to do is sell and let somebody rip the whole thing down and sell for the value of the land. And it's ironic that this has happened now because the legislature has just substantially amended the termination provisions of the condominium statute. So that'll be interesting to see how that all plays out.
But how's that happen when you have a mortgage or
Well,
what's going to happen there?
There are provisions in the new statute as to the amount, the prorated amount that will go to the mortgage holder.
Okay.
Now remember, these condominiums have insurance and there should be significant insurance
Money there,
proceeds.
right.
So even if the property is damaged and you have to sell it for less than you might have sold it when there were beautiful units there,
Right.
you're also going to have the insurance proceeds. And you should have the reserves. Again, if the board has been doing its work properly, you should have the value of the land, the value of salvage, the insurance proceeds each unit owner will receive, and the insurance proceeds that the association will receive.
Yeah, so there's quite a big pie there. Maybe not fully, but it's
I'm not saying it's
enough.
ideal,
Right.
but I'm saying that the legislature has thought about this at least.
Well, thanks for coming on
Sure.
the show today, and I appreciate it. I think we've learned a lot, and our viewers have learned a lot, and hope you come on again.
All right.
Okay?
Okay.
Thanks.